Hello all. Welcome and thank you for attending our first Fighting for Fairness webinar of 2025. My name is Emma Zagant. I'm a legal fellow at the ADA's Legal Advocacy Division and the moderator for today. This six-part series will focus on diabetes discrimination in various fields, with today, of course, being Diabetes 101. I want to first thank the Skadden Foundation for their sponsorship. Additionally, as a disclaimer, this presentation does not contain medical or legal advice. Please listen throughout the presentation for two CLE codes I will announce during the presentation, both in the middle at the end, and then I will pass out an attendance form to fill out so you can ensure you receive CLE credit. Now I'm happy to introduce our two speakers for today, Dr. Henry Rodriguez and John Griffin, two longtime ADA volunteers and experts in their respective fields. Dr. Rodriguez and John Griffin will provide the medical and legal perspective on the diabetes basics. Please feel free to put questions in the chat and we will try to get to all of them at the end. I will now pass the presentation along.
All righty. Well, I guess I'll start off, and our outline was just listed there. There we go. So we're going to start with just classifications, causes and management. I do tend to be verbose, but I will try to keep that concise. A couple of words about complications, and then John and I will be alternating, moving down the list. So those are our outlines, and I think in the interest of time, we'll go ahead and get started. And we'll start off with classification, causes, and management of diabetes. So just brief statistics on diabetes. Approximately 38 million people in the US have diabetes. So, you probably have either a family member, a loved one, or a colleague that has diabetes. About 1.2 million people are diagnosed with diabetes in the US every year. It was a leading cause of death in 2021. Overall, it disproportionately impacts minority groups, and the rates do vary significantly by socioeconomic levels. We know that diabetes can increase the risk of both short and long-term complications. Those long-term complications include cardiovascular and kidney disease, but it's a really important thing to note that people with diabetes, if they manage it well, can live a long life when they have access. That management requires access to proper resources and management plan and a team around them. On our next slide, if you look at primary factors that are fueling the current diabetes crisis, there's no doubt that social determinants play a role. Poverty, lack of access to adequate health care, adequate health insurance, having access to nutritious food, outdoor space in which to be physically active, and medications, obviously major issues. There certainly are biological factors that include age, genetics, and ethnicity that come into play. And then last but not least, lifestyle factors. So true for the general population in general, but particularly for those with diabetes, unhealthy food, physical inactivity that ultimately lead to obesity. These all increase the risk for diabetes development. Next slide. If you look from a financial perspective, the annual healthcare cost of a person that's diagnosed with diabetes is approximately 2.6 times higher than someone without diabetes. And so if you look at healthcare dollars, 1 in every 4 healthcare dollars in the US is spent either caring for the diabetes itself or complications that extend thereof. Next slide. So, and these are very broad strokes, but if you think about diabetes, we'll talk about what's the specifics with regards to how we define diabetes, but it's generally divided into type 1 diabetes and type 2 diabetes. And it really has to do with the body's response to insulin. In the case of type 1 diabetes, it's what we refer to as an autoimmune disease. The body's immune system basically attacks the insulin-producing cells in the pancreas, leading to relative insulin deficiency. Now, it's interesting because historically, people have thought of type 1 diabetes as really exclusively occurring in children, but it can be diagnosed at any age. And the latest statistics actually suggest that over half of the new diagnoses of type 1 diabetes in the US are in individuals that are over 20 years of age. And also important to note, of that 38 million, only about 10% have type 1 diabetes. In the case of type 2 diabetes, it's generally felt to be a consequence of the body's resistance to insulin. So over time, there may be a loss of insulin production, but initially it's that resistance. The body cannot respond to insulin appropriately. In general, type 2 diabetes develops in older adults, but unfortunately, we're seeing it in children 10 years of age or younger. Risk factors for type 2 in particular include genetics, and those issues that contribute to increased risk include physical inactivity, obesity, age. As folks get older, it's more common, a history certainly of prediabetes, and those individuals that have a strong family history of diabetes are at greater risk. Next slide. So we're going to take a moment here to talk about hyperglycemia and hypoglycemia. So hyperglycemia is a technical term for high blood sugar. In general, that's defined as a fasting blood sugar greater than 126 or a random blood sugar throughout the day of greater than 200. That high blood sugar occurs when the body has either insufficient insulin or responds inappropriately or insufficiently to insulin, and it leads to those high blood sugars. Symptoms of hyperglycemia and prolonged hyperglycemia over a matter of hours and days generally develop, and the shorter term hyperglycemia does not really pose an immediate risk of incapacitation or emergency. Now, hypoglycemia, defined as a low blood sugar, less than 70 milligrams per deciliter. For those that are used to dealing with these measurements in Canada or Europe, it's measured as 3.9 millimoles per liter. It's a potential side effect, certainly, of insulin and other diabetes medications, and it can generally be self-treated. In the case of severe hypoglycemia, that's defined as a low blood sugar that requires for that individual the assistance of another person to actively give them carbohydrate, glucagon, which is a medication that raises their blood sugar, or other interventions. So severe hypoglycemia is an emergency situation. Next slide. So if we spend a lot of time talking about diabetes management, and so management strategies and tools for a person with diabetes that allows them to properly control their diabetes condition, that really depends on their type of diabetes, whether they have comorbid conditions or other health conditions, their environment, and other factors. And it's important to realize that every person with diabetes is different. Some tools that we can use to manage the diabetes, many folks utilize insulin injections or insulin pumps. Increasingly, those devices those pumps work with continuous glucose monitors and what we refer to as automated insulin delivery. So these devices use the glucose data, the blood sugar data that comes from these monitors to adjust insulin delivery, in part automatically. We know that medications, particularly in the type 2 space, can include metformin. There's a class of drugs called DPP-4 inhibitors, sulfonylureas, and as has been increasingly in the media, GLP-1 medications. Physical activity is critical. It's all good for all of us, but it's critical for those individuals that have diabetes. And as you might imagine, in utilizing all these tools, lifestyle management is a key part of this. Next slide. So if you look at diabetes-related complications, it's important, again, a take-home message here is individuals that have type 1 diabetes, if they're successful in managing it well, can delay or prevent complications. Again, it requires medication, lifestyle changes, regular visits with the healthcare team. As an example of these complications that we're trying to avoid, it's important to note that 80% of non-traumatic lower limb amputations in the US occur as a consequence or a complication of diabetes. We know that hearing loss is twice as common in people with diabetes. People with diabetes have twice the risk of stroke than the general population. We know that other complications, including heart disease, kidney failure, and diabetes retinopathy, which is damage to the eyes that, quite honestly, is the leading cause. These complications in people with diabetes is the leading cause of blindness in the United States. And so these complications can create different legal needs. And so different accommodations may be needed, not only for that individual to manage their diabetes on a day-to-day basis, but to address these complications. They may require access to an elevator or use of a stool or having a chair available, assistive visual devices as just examples.
Henry, when you mentioned complications, my thought came to mind is that diabetes doesn't just present physical complications for people with diabetes. They present legal complications for people with diabetes in their lives.
Indeed.
And we see that in schools, employment, public accommodations, prison settings. And those complications are a different kind of complication, because the complications that we have in the law is that diabetes is commonly misunderstood. You have shared with us the differences between type 1 and type 2 diabetes and the different facets that they have. But there are many stereotypes that, contribute to a misunderstanding by employers and others about diabetes. For example, there is a stereotype out there that I've seen, and a lot of us have seen over the years, that if you are a person with type 1 diabetes, or your client or patient is a person with type 1 diabetes, that's not their fault. That's just a genetic irregularity. There's nothing they can do about it. They don't deserve it. And type 2 patients and clients, sometimes judges, others have a stereotype of people with type 2 diabetes that they brought it upon themselves. They should have lost more weight. They should have better cholesterol numbers. They should have not combined it with smoking or hypertension. All these other ways that they get stereotyped. And so it is commonly misunderstood, and that it happens in school settings where children are segregated, or the school does not want to provide any way to assist the child with their insulin needs or their blood glucose management. It can happen in the workplace where people are not allowed to go into concerts and bring their supplies with them. It can also happen when people get low blood sugars and they are apprehended or in a law enforcement interaction, which the symptoms are often confused with some sort of misconduct on the part of a person with diabetes. So all these things happen. People with diabetes sometimes want to live a pretty normal life, and so they don't disclose to others that they have diabetes. Sometimes they are afraid to challenge discrimination because of retaliation. But the fact is, in today's world, employers and others sometimes do have restrictions and attitudes toward people with diabetes that we wish they didn't have. For example, we see employers take things that Henry and others have said about the best practices for being a patient, and then using them against those same people in the law by saying, you didn't have your A1C below 8. You had a blood sugar of 58 when you were sleeping. You are not a good patient, therefore you are not equipped for this job. We see that. We had A1C cutoffs. Some employers actually put in writing, if your A1C is above 8, you can't have the job, whether you're type 1 or type 2. But these are the kinds that we've seen. And so when we talk about examples of discrimination that we face and that we still face even in 2025, we have an employer, for example, who won't allow a worker to monitor blood sugar, to check blood sugar, to administer insulin, or consume carbohydrates at work. All of those things are important. Some employers have rules of no food at the desk, or no food in the workplace, or no administration of any medication while on the job. Those are examples of discrimination that occur that, as we know, are contrary to the Americans with Disabilities Act and the Rehabilitation Act as well. What happens commonly, as some of you may have seen in clients, is that people have to go through a process to be hired, and it's illegal for the employer to ask about disabilities before they hire them. So they go through the process, they like the person, they send them an offer, then there's a physical requirement that they go through and undergo a physical. Then the employer finds out about diabetes, and then they say, you are not qualified any longer, either because of misunderstanding, A1C cutoff, erratic blood sugars, you name it. They have all kinds of ways of rescinding offers for people who have diabetes, even though they have previously held them to be qualified and ready to go. Over the years, we don't see this as often anymore, thanks to the efforts of Henry and his colleagues and lawyers around the country. People with diabetes were commonly excluded from certain positions like Coast Guard captain, airline pilots, bus drivers, certain law enforcement officers, because of the mere fact that they use insulin. And thanks to the efforts of a lot of folks around the country, most of those blanket bans are dead and gone. But there are occasionally employers who are still living in the dark ages and make an assumption that if a person is on insulin, that somehow they are a safety threat, when the science does not back that up. Also, children are sometimes held to be different, and that therefore, to help them, we are going to send them to another school to help them. It's a different way, in my view, of separate but equal. Oh, they're going to get an education, but we're going to lump all the people with disabilities together, and they're going to get a just as good an education as their colleagues and friends who don't have a disability at all. And so what is the legal framework that governs all of this? And we have had, since the 1990s, the Americans with Disabilities Act. We found that the act wasn't working, in that courts had contorted the law to say the better a person with diabetes does with their diabetes, the less protection they had under the law. The courts were saying, you have type 1 diabetes, but you're living such a normal life, it's not a substantial limitation on anything. We have a right to fire you because of your diabetes, and you have no protection because you're doing so great. Paradoxical that was to many of us, and we'll talk about our approach of educate, negotiate, litigate, and legislate. But in that went all the way through all four, and we got to the legislative stage. And in 2008, Congress passed by overwhelming margins a change in the Americans with Disabilities Act to make it clear that we will never, ever punish a person for or a client or a patient for doing well with their diabetes. And what does that mean in plain English? What it means in plain English is a person has a disability with diabetes, regardless of medication, insulin, weight loss, oral med. None of that has any effect. The only question nowadays under the Americans with Disabilities Act is, does this person have a major limitation on a major life activity? And so what did Congress do? Congress said, we're going to stop this discrimination because we're going to make metabolic function a major life activity. Granted, it's not like driving, it's not like walking, it's not like interacting with others, but Congress has said when a person has a major impairment in their endocrine system, they have a disability, and that disability is diabetes. And all diabetes is a disability nowadays, because if it's type 1, there's a complete inability for the pancreas to secrete insulin. If it's type 2, it's a major limitation in the body's ability to absorb insulin into the insulin receptor cells. And those are both major limitations on the way our body works. So first rule is make sure the diagnosis of diabetes is in the record, and make sure somebody has pointed out that this diabetes is a major limitation in that person's endocrine function, even though it goes without saying. There are other forms of disability discrimination that we see occasionally. A record of an impairment where an employer sees something in writing and it's mistaken, or it takes a position adverse to the person. But C is a really important definition of disability. That is this: an employer who regards somebody as having an impairment, even if it's not diabetes, even if it's only pre-diabetes, and the doctor writes, this person has pre-diabetes, they have these factors. If the employer acts on that, pre-diabetes may be an impairment in some way, that is a minor impairment of the endocrine system, but they're still protected if the employer mistreats them on the basis of pre-diabetes, because that's an impairment, but it's not substantial and it doesn't interfere with the person's ability to do the job. And so these are major changes in the way that the ADA and the Rehabilitation Act have been interpreted. And we are seeing, although it's important for all of us in this area to be aware of this, most cases should not be lost on the stage of the case about a person having a disability if they have diabetes. They ought to have a disability. And the next question would be that they are able to perform the essential functions of the job. And so what are those elements? We talked about first, you still have to show that a person with diabetes does have a disability. And when we use the word disabled, like on the screen, it doesn't mean they're actually disabled from doing things. It means that they have a major limitation in their endocrine function. And so we see now endocrine function on your screen, and that is the definition in the regulation. And it talks about diabetes as being normally a per se disability. And so those are important factors to keep in mind when we're talking about potential clients, whether in a school setting, public accommodation setting, or employment setting. These definitions are basically the same. Henry talked a little bit about accommodations. Employers only owe accommodations to workers who have an actual disability, that is diabetes. They probably don't have to accommodate pre-diabetes unless somehow it's a substantial limitation in endocrine function. But we'll talk about accommodation. Henry's going to talk a little bit more about accommodation a little bit later. But that is sort of the playing field that we have when it comes to diabetes. Now, there are other laws that apply in different kinds of contexts. Most of you are aware that the federal government occasionally does not treat people with diabetes with the respect the law requires, and the federal government is liable in that event under what's called the Rehabilitation Act. And that law is much older than the Americans with Disabilities Act, but contains many of the same sorts of protection. And you can see from the screen that it covers employers in the executive branch of the federal government. And all Section 504 also applies to kiddos at school, and it prohibits schools from treating children with diabetes in an unfair manner. And we know there's a lot of ways that can happen. And we've also found that when it comes to young kids at camps and daycare programs, there is often some stray daycare people who misclassify or refuse kids with diabetes to be cared for, or want to care for them in some way that ties the hands of the child to be able to manage their diabetes in a way that helps them. Also, we have a lot of you are from different states, and most all of our states have a labor code of some connection to the ADA. In Texas, where I am, it is basically word for word the same as the Americans with Disabilities Act, but there are different remedies under state law. For example, some state law allows more damages than under the ADA. Some states have different causation standard. That is, Texas has a motivating factor standard under our law, whereas federal law, it's because of. It doesn't matter a whole lot. But some states may have laws that are more palatable to us folks helping people with diabetes in state court as in federal court. We also have to consider who would be the judges on these sorts of cases. Are the judges likely to be interested in diabetes, or does the judge have proclivities to just dismiss all disability rights cases on summary judgment? And so those things are absolutely important when it comes to deciding whether to proceed under the ADA or under the Rehab Act or under state law. And so at this point, I think it would be logical, Henry, if you could talk a little bit about accommodations and ways that we can help employers help workers with diabetes.
Real quick, before we do the next slide, I'm just going to announce the CLE code. And this will also be in the chat box, but code 1 is 3142. That is 3142.
Thanks, Emma. Thanks, John. So again, I think a really important theme here is to realize that depending on an individual's diabetes and the tools they use and the way that they manage their diabetes, and as mentioned, complications that they may have, the accommodations are going to have to be tailored to that individual. So if we can go to the next slide. Yeah, so I'm a pediatric endocrinologist by training, and so I take care of children and young adults that have diabetes. And so in the school setting, some examples of accommodations would include, those children that require medication at certain times of days. We know, for instance, for children with type 1 diabetes that require insulin, they're going to require a blood glucose check and insulin administration if they have breakfast at school or at lunch, or if they're at school snacks, and birthday parties and the like. Individuals need to have their medication, their supplies, and equipment. So if a child utilizes an insulin pump, they need to have those supplies available and backup supplies. So if their pump for some reason malfunctions, they need to have the ability to administer insulin by injection. I mentioned meals, so school lunch accommodations. They need to have, particularly for children with type 1 diabetes, they need to have the carbohydrate content of that meal that will allow them to determine how much insulin they need in part. And so nutrition information is very important. Providing that to parents ideally ahead of time is an accommodation that's necessary for those children. Fortunately, we don't have too many children with the kinds of complications that would limit their ambulation because of their diabetes, but they may need use of an elevator or a class that's in a different location of the school. It's really important that, particularly for younger children, that either a school nurse or other employees at the school are responsible for assisting that student in managing their diabetes. We mentioned the emergency of severe hypoglycemia. So being able to treat a low blood sugar, ideally prevented, but also administration of medication, in this case it would be glucagon, in an emergency situation to raise that child's blood sugar. It is not sufficient for the school merely to call 911 and await for EMS to arrive. That's just not acceptable. Bathroom breaks. One of the symptoms of diabetes, of high blood sugars, is frequent urination. So these students should have access to the restroom, and really also in turn, more frequent urination is going to lead to dehydration. They need to have access to being able to drink water and fluids. And again, the ability to monitor their blood sugar, allowing them to not only have a private space potentially to test their blood sugar, but taking the extra time to monitor their blood sugar before, for instance, they go to lunch or before an exam and so forth. So again, in the school setting, these are just a few examples of the accommodations that may be necessary. Next slide. So if we turn to the employment settings, I mean, these are individuals in whatever employment environment they may be at, they will require breaks to check their blood sugar, either because they're about to eat a meal or they're feeling symptoms of high or low blood sugar. They need to be able to do that. And so with a low blood sugar, they're going to have to eat something to help raise their blood sugar and prevent a serious or severe low blood sugar, they may be able, they should be able to have their medication with them, administer their medication, use the bathroom, as mentioned in the school setting. They should have, again, a place to rest. And in the case of a low blood sugar, if for it to come up before they resume their job-related activities, again, the ability to keep their supplies and food nearby. So again, it's really important for these individuals that they be able to manage their diabetes proactively so they don't encounter a situation where they have a severe low blood sugar, or quite honestly, that their blood sugar is so high that they're feeling poorly and are not able to perform in their given job. They have to be able to test their blood sugar and inject their insulin or potentially take other medication anywhere at work. There should be modifications to no-fault attendance policies. These individuals not only require routine medical visits, and it may be with their physician, it may be with a diabetes educator, and so forth. So they have a number of requirements, and they should not be penalized for attending those visits. They should have appropriate leave for treatment, recuperation, training, managing. As you can imagine, a layperson being faced with the fact that now they're going to have to test their blood sugar, they're going to have to inject medication, they're going to have to utilize these technologies, whether it be insulin pumps or continuous glucose monitors and so forth. There's a lot of training and education that's really required for them to manage their diabetes well. And so there needs to be the accommodation there for those needs as well. For those that have diabetic neuropathy, neuropathy is a potential complication of high blood sugars, diabetes for an extended period of time. That may require them to have use of a chair or stool to be able to rest, and they may not be able to stand for long periods of time. Next slide. So for those individuals with diabetes that do find themselves in a detention facility, accommodations are very, very important there as well. These individuals will require a modified meal and snack times. Again, they should have available nutrition information. They should have ready access to snacks and their diabetes supplies. And, it's critically important that, again, similar to the school setting, in the detention facility, there needs to be staff trained on diabetes care and responding to diabetes care, diabetes emergencies, excuse me. And again, these individuals in many cases are utilizing, and maybe a technology as simple as a blood glucose meter, but they need to have access to that technology, including insulin pumps and continuous glucose monitors. These are tools that many individuals with diabetes use on a day-to-day basis. And so the ADA does have a recent statement that's been published and available online, the detention setting statement. And so this is entitled Diabetes Management in Detention Facilities, a statement of the American Diabetes Association. And I would encourage any of you that encounter clients that have this particular situation to avail yourself of that information. John, you're muted at the moment. Sorry. One of us had to do that.
Thank you for that. Henry, echoing what you said about the detention setting, for those of you who are looking for authorities to assist courts with diabetes issue, the ADA publishes every January clinical practice recommendations, and with those clinical practice recommendations are official policy statements. And while they're helpful for patients, they're really helpful for lawyers because they take a very, very much of a scientific approach when it comes to driving issues, detention issues, employment issues. And it takes on most of the problems that employers impose on people with diabetes in a way that we have found that judges, even appellate judges, take as authoritative, as well they should, because they're written by some of the top endocrinologists in the world. And when the ADA puts these groups together, They're from Europe, Scotland, the United States, and include the experts in the field that are well regarded. And so that's out there for all of you to be able to rely on. The second point about accommodations, to echo what Henry was saying, accommodations from a legal standpoint are something that the employee has to bring up the need for one. It's not generally the employer's job to go out and find out who needs one. And so it requires the worker to be able to say, for me, I need this accommodation, and there'll be adverse effects if I don't do it. And once the employer is given notice of that, it's up to the employer and the worker to have a good faith dialogue to talk about what's needed, how it can be provided. And at the end of the day, when we advocate for an accommodation, it's up to the employer then to be able to say, this would be an undue hardship, cost them a lot of money, mess up their work, mess up their core of their business. And so those kinds of accommodations are important. And it's also important to know that, as those of us who've been doing this for a while, there are always weeds that come out of the ground from employers who want to try to find a way to exclude people with diabetes or disabilities. And one of those ways now is to take the position that accommodations are only for one purpose, and that is to actually facilitate the worker doing the essential functions of their job, which, if that weed ever got out of the ground very far, it would mean the accommodations of having food at your desk, having a stool, those sorts of, or would not necessarily help the worker push the cash register button, or would not necessarily help the worker turn a wrench or do a plan. And so we're seeing that. So it's always good to try to tie an accommodation to the job, but it's also important to point out that the accommodation is not just to help the worker do a better job. It's also to help the person in a public place or a detention facility to avoid the catastrophic symptoms of diabetes, such as devastating hypoglycemic episodes, low blood sugars, and to prevent long-term complications. And so those sorts of accommodations, that is an area today where employers are fighting that beachhead on accommodations much more aggressively, I've found, than in years past, because the other ways of challenging people with diabetes have been cut off. The courts and the Congress have made it very difficult for them to just categorize people with diabetes and segregate them or mistreat them. So accommodations are a hotbed of activities, and we all ought to be prepared with that. Now, when we advocate for accommodations, we also advocate generally for people with diabetes and for people with disabilities in general. And one way of doing that, always the strategy of ADA and our volunteers and lawyers, or we start by just having to be able to educate folks. We do seminars for employers. We publish clinical practice recommendations. We want employers to have the best information about diabetes that they possibly can have, because if they do, they're more likely to be able to integrate people with diabetes into their workforces. And we can educate them that people with diabetes are often some of the best workers, the most disciplined workers, and the most successful workers. So if we educate them and they're open to that, that prevents the need for ratcheting up, if you will, the heat when it comes to diabetes-related issues. Sometimes there is a need to negotiate, both with the federal government in some cases, successfully in some cases. There were no foreign service officers with type 1 diabetes for decades. Through a lot of negotiation, that finally stopped, and we have now foreign service officers all around the world now who utilize insulin to manage diabetes. And so negotiation is the second step in our approach to dealing with issues with people that have diabetes have in workplaces, public accommodations, schools, and detention settings. We are not afraid to litigate, however. There are times when the federal government or other employers say to us, we hear you. We are not going to play ball with you. The FAA was one of those about 10 years ago. We had meetings with them. We had constant meetings with the federal air surgeon. We had an expert panel headed up, I want to say, by Dan Lorber or Des Schatz, pioneers in the endocrine, fabulous doctors. They said thank you, but no thank you. And it took 2 lawsuits and 2 trips to the DC circuit before the FAA finally did start approving well-managed pilots who happen to need insulin to monitor their blood sugar. And so litigation has opened up that door. Litigation has opened up the Coast Guard door. It has opened up police department door. It has opened up the FBI door, all either judge or jury driven cases that have required employers to judge people with diabetes on their actual abilities and not on the diagnosis or the facets of diabetes that they have. The fourth one is legislate. And having been through the 2000 to 2008 time period, we at the ADA and lawyers in the disability rights movement had tried the first 3, and it wasn't working. In fact, it was working so poorly that appellate courts were saying that a Walgreens pharmacist could be fired or not able to administer insulin at work. And that pharmacist lost his job with, I believe it, I'm not sure, Walmart or Walgreens, but lost his job. And that rang true to a lot of us at that point, that if that guy, a marathon runner, an athlete, a perfectly managed patient, who's a fantastic pharmacist and loved by those around him, if he gets frozen out and the courts have failed us, we had a duty to go to Congress and say, fix this law. It's not working. And it was something that I think was miraculous in some ways, because we learned that both parties have loved ones with disabilities. And we also knew that the first President Bush was one of the premier advocates for people with disabilities. And our thought was the second President Bush, even if he didn't necessarily agree with us, would probably not get in the way because of his dad's legacy, and because we hoped he'd had a soft spot for people with disabilities. At the end, it was passed, I want to say, with 1 no vote in Congress, which was the only civil rights bill that the second President Bush signed in his term of office. But it was something that worked, and that we do need to know, we do need to be aware that in our arsenal, that we need to be aware of things that the courts, negotiation, and education hasn't worked. And we are monitoring right now to see whether a weed grows and says that you don't get an accommodation to go to the doctor, you don't get an accommodation to have your carbohydrates, you don't get an accommodation for things that help you avoid long-term complications, because you can do your job actually without those accommodations and you still get good ratings. Therefore, you don't get an accommodation at all, even if it prevents complications down the road. If that weed ever comes out of the ground much further than it has, we will start considering telling Congress, again, the courts are saying your law is not working for people with disabilities the way it should. And so our approach has been to do that. And so if we can go to the next slide, I believe we want to talk about the factors that how we decide which of these stages we're in. One is, what's the likelihood of success? We don't want to charge at windmills. We are not Sancho Panza. We're not out to just for the sake of fight. There's a goal in mind. We also consider how many people are affected by what's going on. Is it an aberration, or is this something that's popping up around the country? Exhaustion. Is there some duty that we have to figure out to go through some administrative routes before attacking in the courts? With the FAA, we had that requirement. We had to go through the Administrative Procedures Act and require the FAA to issue rulings before we could take action. Also, we have to consider whether something has happened to cause it to be a moot point, or that is, they fixed the problem or it's sort of worked its way out in some way. And then we also like to consider, could this have an adverse effect on retaliation? And sometimes we as lawyers have to tell clients, you can ask for this accommodation, but can you achieve the same purpose for which you're asking for this accommodation in another way that doesn't embroil you with the employer with an accommodation request, especially where the employer is not well versed? There may be more than one way to skin a cat that doesn't involve a request for an accommodation. And sometimes people can bid for a work shift change. Sometimes they're in unions. They have a right to move things around that helps them better take care of their diabetes. And it's not an accommodation, it's just a move around. So those kinds of things matter. And then, of course, time and cost. The ADA has invested significant time and cost in 2 or 3 different kinds of scenarios. One is children in school, because there was an issue that parties were taking the position that you were practicing nursing or medicine to help a child administer their insulin or measure their blood glucose while at school, when it's not the practice of medicine. Uncles, grandparents, everybody knows how to help a kid with their diabetes. But that case went all the way to the California Supreme Court, involving extensive time, expense, labor to make that happen, including the involvement of the federal government in that state case out in California that ended up with the California Supreme Court ruling for kids with diabetes and said it doesn't run afoul of any medical or nursing standards for trained volunteers to help kids when they have a problem at school with diabetes. And so the other one was, of course, the FAA we talked about a moment ago. That was a 10 or 12-year effort involving tremendous resources and talent being thrown at the problem. Fortunately, today, pilots are in the sky, safely carrying us around the United States and around the world. And the FAA, while it is still not altogether transparent in how it decides which pilots with insulin-treated diabetes it will accept and which it won't, we have made that factor. Those were 2 cases in which time and cost were high, but it was worth it because of the other factors. A lot of people were being affected. Well, we thought we'd probably win. We've done all the exhaustion we could do. We had to go for the goal line, and it finally did happen. And so those are the factors that we consider. And so at this point, I think would be helpful, Emma, if you would talk to the folks about opportunities that we have and that opportunities that we have to make a difference.
Great. Yeah, thank you, John. So these are already some resources, what were hinted at, what I'll go over. But first, just want a reminder that there's 5 more webinars in the series, so it'll cover a lot of these topics. If you, whoever you represent, there will be a focus on education, one on detention settings, employment, public accommodations, and it'll be wrapped up with a case law year in review. And you can register at the same link you probably registered for this one, diabetes.org/fighting-for-fairness. And then a few of the resources we have, like was mentioned, the ADA standard of care in diabetes. All of this will be sent with materials following the presentation, but this is a great resource that's updated every year. And shows all current clinical practice recommendations of the ADA and of experts. So it's a great tool to have, whether you're talking about accommodations and representing a client, or just trying to understand more about what's the latest recommendations in diabetes care. Another opportunity we have is to join the ADA's Legal Advocacy Attorney Network listserv. So if you sign up for this listserv, which will be sent out later, you can receive referrals from the ADA, learn about pro bono and amicus opportunities, and also gain access to medical experts and referrals if you're representing somebody with diabetes. And we can also share more of our resources if you reach out to this contact. More of our resources are on our attorney resource page, which will be linked on this PowerPoint, which you will receive later on.
Hey,
And
Emma,
then a
could-
reminder, we're going to enter into the Q&A time, and then at the end of the Q&A, I will repeat the second CLE code and send out that attendance form, give people some time to fill it out.
Emma, are you there?
Yes, are you able to hear me?
I wanted to cheerlead on what you said about helping lawyers get experts. I myself have been the beneficiary of having the world's best testifying experts in cases because they're volunteers like Henry who help us lawyers win cases. And so it's hard to find medical experts in disability rights cases, but there is a wonderful wealth of scientific and clinical expertise in our stable. And so don't hesitate to use the resources that Emma has just shared.
Yes, yep, wonderful. So I'm going to start the Q&A now. The first question I have is for either of you, but maybe discuss both the medical and then the legal side. But could you discuss how new diabetes devices such as continuous glucose monitors and now insulin dosing capability and such available on smartphones, how does that influence legal needs or challenges for people with diabetes?
Well, I guess I would just start, if I may, John. These devices are phenomenal. I think they have the potential to dramatically decrease the burden of managing diabetes day to day. Having said that, any of us that have had a smartphone realize that they're not foolproof. And so, as I mentioned earlier, I think as we think about accommodations, not only having access to those devices, but having access to devices and supplies such as blood glucose meters and insulin pens and syringes and so forth is incredibly important. And I guess I just wanted to come back to the issue of accommodations for a second, if I may. As John highlighted, I think it's really, really important. It's not just the accommodations for that individual, whether it be a student at school or an employee in a workplace, to be able to do that job. We as clinicians empower patients, and they have to manage their diabetes day to day, not only to maintain their health at the moment, but to really mitigate their risk for the kinds of complications that can be devastating long term. And they need to do that 24/7. So they need to have those accommodations at the school, at the workplace, in order for them not only to do what they need to do, learn at school, perform their job at work, but to take care of their diabetes and prevent complications.
And Henry, in terms of the technical improvements that we've had in terms of caring for diabetes, I myself am a beneficiary because I'm looking at my smartphone and know what my blood glucose reading is. It is a wonderful tool for patients to make their lives better and to make their lives easier, because sometimes people get busy. They don't realize their blood sugar is heading toward the 50s or 60s. And these blood glucose, continuous glucose monitors actually warn us, hey, you're heading downhill. You can avoid even getting in that range by having some carbohydrates. That's a plus. On the other hand, employers have to be educated on the benefits of those programs, CGMs, for example. They are misinterpreted sometimes. Often patients in the night will have blood sugars in the 50s or 60s. Their CGM goes off, they go get some carbs, everybody happy. Some employers take that as uncontrolled diabetes. They cannot work at all, when it has zero effect on their actual ability to do their job at work. They could be drinking and be drunk off work. It doesn't keep them from going to work unless they show up drunk. But we saw this kind of discrimination happen. And so, and even with the best of technology, some employers will hire some doctor to say, well, sometimes CGMs have erroneous readings. And so our thought process in employment cases is use your CGM, but make sure you have a glucometer. If you get a weird reading that says 42 and you don't feel low, repeat it with a finger stick, just to get an extra level of security. So those two different kinds of technologies, pocket glucometers and CGM systems, very important for the lives of people like me, but they're also important to know that they can be misunderstood by employers. And those devices, though, are the reason why pilots are in the air. That finally the FAA was persuaded that there was no good reason that they couldn't know what their blood sugar was in the aircraft at all times, to even conjecturally show that they weren't going to crash airplanes. And so, yes, that very, very good question. And technological devices normally shouldn't involve accommodation, because that wouldn't be an adjustment of the employer's rules or policies, unless they have a rule against having a glucose monitor, or but they usually don't, because they have people with pacemakers or other kind of implantable devices. So, but yes, that's a very good question and important area of medical technology, how we've improved.
All right, thank you. So I see we have a question again about where to find the clinical practice guidelines. And like mentioned before, that would be the ADA Standard of Care in Diabetes. There is a web page and also a more shortened, condensed version, and this is updated each year. This will be sent out with the materials in this PowerPoint. But a question off of that, I believe this will be our last question. So maybe one of you respond, or both, just a little shorter. This question was, diabetes, of course, is a 24/7 condition. People can't have breaks. How can an attorney just better understand and show that their understanding of the challenges somebody's faced, not just legal, but like the day-to-day challenges?
So I guess in that vein, the first thing I'd say, sorry, John, is you have to understand that even individuals without diabetes at all, their blood sugars aren't exactly the same all day long, and they vary. And they vary in response to, eating, to exercise, activity, physical exertion, and so forth. And so, as John mentioned, there are lots of tools that are available to assist in the management of diabetes and controlling blood sugars. Again, it depends on the individual affected, what kind of diabetes they have, what they have chosen with the healthcare provider in terms of what tools they use, and what the accommodations should be. But as I said earlier, in all the years that I've been assisting individuals and families with diabetes, the technology has made a dramatic difference.
And just to finish up, but very briefly, diabetes does have burdens. The technology can be a burden. It is a very, very 24/7, no vacations from it proposition. And there are some of us, myself included at times in the past, when I've gone to see a life coach or a therapist to walk through what's going on in my life, because it wasn't where I wanted it to be. And so nobody understands that burden better than those who are living it. And so for those of us in the law, it's important that we understand that when that client comes in the door, they come with the whole package of living 24/7 with the disease that 40 million Americans have.
Hey. Thank you, John. I think that's a great reminder and way to close this out. So I'm now going to go for the CLE, give everybody some time to fill out the form. The last code will be put in the chat, but then it is 0812. That's 0812. I'll give everybody a few moments to either scan the QR code or click on the link. The CL link was also put in the chat. I see there's some questions about that, so you should have access. It should be sent to everybody. If you have any issues, just mark down the codes and you can email us right after this. A good contact information, which will also be put in the chat, is attorneynetwork@diabetes.org. So feel free to reach out to us at that email. Thank you much, everybody, for attending. We'll stay on for just a couple more moments for you to get access to the link, but we appreciate your attendance.